It was in the order back then for her to be assessed for services at Spindletop, which never happened. So here's the thing. Here's where I am. I don't disagree that, Miss Lewis has really no criminal history. This is the only case. There's clearly some mental health issues as well as drug issues. Mr. Whitmire, in cause number 25, DCCR 0057, you're charged with a second-degree felony offense of possession of a controlled substance from October 12th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Whitmire is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance, sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that for any time that you've been in custody that the law gives you the right to receive. I'm going to sign a dismissal as part of this plea agreement and clause number 25, DCCR 0056. I've handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Just thinking about yesterday, and this is a possession case, so I'm not sure how it applies. But because of the judgment entered against you, you could be ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas and read that document carefully. All right, you can go back with the bailiff.
Thank you.
And this is cause number 25, DCCR 1019. Mr. Harmon's charged with aggravated assault with a deadly weapon. And 26, DCCR 0385, charged with assault of a public servant. And what is the announcement?
Yes, he wants to trial. I've conveyed it.
Is the offer, let's see.
Judge, he had previously rejected 15. I re-urged that today.
Okay.
This is their first appearance with this newer charge.
Right.
That was indicted in March. And my offer was for them to run concurrent.
So 15 years in each to run concurrent?
Yes, Your Honor.
And so when we've gone over this before, Mr. Harmon, when it was just the one case, that if you're found guilty in either of these cases, the range of punishment would be that of a habitual offender, if that prior criminal history is correct, which means your minimum punishment would be 25 years in prison up to 99 years or life. And you understand that?
Yes.
And you understand the offer of that 15 years is now for both cases to run concurrently or at the same time. You understand? Yes. And you want to go forward on both of those cases to trial. Is that correct?
Yes, I was wanting time though to hire an attorney. My people are going to give me an attorney.
So here's what I'm going to do, just because this has been going on for some time. Obviously, if you get an attorney hired, they can step in at any time. They need to do that as quickly as possible because I'm going to move your cases to the trial docket. Yes. Mr. LeBlanc will begin preparation for trial. And if they get someone hired, they'll substitute in. Otherwise, he will go ahead and be prepared when that trial day comes up. Okay.
Okay.
All right.
And Judge, also that second case, I believe it could be they try that and then you can turn around and try the next one as well.
Yes, Judge. We'll be seeking to stack.
So, Mr. Harmon, also, and I know you've gone over that with him as well, Mr. LeBlanc, that if you're found guilty in both of the cases, because those are different offense dates, that the cases could be stacked or run consecutively. If you're given a sentence in one and then they go to trial in the next, then the district attorney's office can ask me, and then it's up to me if those cases are stacked or run at the same time. Do you understand?
So it would be stacked, not concurrent?
It would be up to me. So it depends on, if we go to trial on both of those cases, I would hear all the evidence in both of the cases. And if I decide that whatever sentences you're given in each of those cases, if I think they need to be stacked, then that's up to me. It's not a jury question, it's a court question. Okay? The plea agreement, if you wanted to enter a plea, is negotiated that they would run at the same time if you wanted to take the plea deal.
Oh, okay.
But if it goes to trial, then it becomes up to me if you're found guilty in both. Does that make sense?
Yes, ma'am.
Okay. And you want to go to trial?
Yes, ma'am.
All right, we'll get it set for trial then. You can go back with the bailiff. Good morning. Are you Justice Joanna Lewis?
Yes, ma'am.
And this is cause number 24, DCCR 0766. Ms. Lewis was granted probation for aggravated assault with a deadly weapon back in September of 2024. This is a motion to revoke. She pled true to counts 1, 2, 3, and 4. I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
We have your stay asked.
And this was unagreed, correct?
Correct. Yes, Your Honor.
All right, Mr. Parker, you may proceed.
Your Honor, just first like to point out she has no new cases. Part of her issue, I mean, she's not reported. She's claimed some mental issues, which although the probation department didn't have knowledge of, I think they've confirmed that by talking to the infirmary, the jail. And I believe she did have issues. She was in a wreck, and I can tell you, she's acknowledged to me that she's told me the right things, which was promising, that she didn't go to probation because she was in a wreck and she was uncomfortable and it's hard to her. She also acknowledges, I should have gone. I should have had better contact with my probation officer and done what I'm supposed to do. She's very convincing to me that if she's given the opportunity, she's taking the medications that she needs to take, and that she will be able to complete her probation. I'm asking the court to put her on a high medium caseload and see if she does what she says she can do. If she's on her medication, and we can see if she actually will report. I mean, it won't take long to see if she reports and she starts doing her community service. They're administrative violations pretty much, and I'm asking the court to give her another chance. And do you want to address the court? Hold on. And she'd like to address the court, Judge.
Go ahead.
I would like for another chance, and I promise that I'll make sure that I do all my things that I'm supposed to do for my probation.
Explain to her what you told me about why you didn't do what you were supposed to do the first time.
I got in a car accident, but like I say, I'm not using it as an excuse. But I was out on transportation and stuff like that, and I couldn't really make it to where I was supposed to make it. And I've been taking my medicine. I've been doing everything that I'm supposed to. And I promise that I'll continue doing everything that I'm supposed to do to complete my probation.
And you told me what should you have done when you weren't going? You should have done what?
I should have reported.
And you should have communicated with them.
I should have communicated, especially with my probation officer.
Mr. Coleman?
I don't have much to offer, Judge. Same things and making representations that they're easy to do and easy to say, but it's the deeds, the actions of the defendant that matter. And Judge, she's essentially done nothing on probation. If it's a mental health issue, she's got to take the first step, Judge. She has failed to enroll in Spindletop to get those mental health, mental health issues, if any, addressed. You can't do this probation for her, Judge. And the definition of insanity is doing the same thing over and over and expecting a different result. Putting her back on probation, given the fact that she's just utterly failed, would be, in my opinion, doing insanity, doing the same thing, expecting a different result. She's just not going to. Her past behavior has indicated she's just not going to be successful at probation.
Your Honor, I don't think that's fair representation, because obviously the probation department didn't know she had a mental health issue. They acknowledged that. And when they do know that, they take steps to help these people that have problems. And she did take steps to get on medication, and she has improved by being on medication. I think with the assistance and the knowledge that the probation department has, that she has a mental health issue, and she actually is taking medication for these problems, it may help her, and she may have a better chance.
So So I'm looking back at the original pre-sentence report from 2024.
Mhm.
And so it was noted in that pre-sentence report in 2024 that she had an appointment with Spindletop for a specific day that she failed to show for during the pre-sentence report, that time period. So it's not a surprise to anyone that there was some issues back then that weren't followed through with to go to Spindletop. That was ordered at it was in the order back then for her to be assessed for services at Spindletop, which never happened. So here's the thing. Here's where I am. I don't disagree that, I mean, Miss Lewis has really no criminal history. This is the only case. There's clearly some mental health issues as well as drug issues. But I'm not going to just say, okay, go out and do Spindletop, because we've already said that a couple of times. So what I am going to do, and this is your opportunity to take advantage of this, Ms. Lewis, is I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. I'm going to find those counts true. I'm going to find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation, but I'm going to order that you enter and successfully complete the special needs safety program. That will address all of these problems. If you say you want and need help, won't matter if you have transportation, you'll be in custody to get the help that you need. Either you take advantage of that or you don't.
Yeah.
So you're going to get all the tools for both mental health issues, drug use issues, self-medicating, all of that. And when you get out of SafeP, you'll be on the high medium caseload in order to do whatever it is to follow up with Spindletop, follow up with drug treatment. And at that point, if you don't do it, there's no arguments that your attorney can make that would convince me that you should get another chance. This is your chance. Do you understand?
Yes, ma'am.
So this was not an agreement. You do have some rights to appeal. I'm handing you that written certification. I hope you take advantage of this and get everything you need because you'll be given that opportunity. Okay.
Yes, ma'am.
All right. Good luck to you.
Thanks, Judge.
Thank you.
You got one more case for coming to beat up for me.
See,
It's a, we're calling it, it's a bond.
it's a bond hearing. Let me see what that one's. I'm just going to number the case on Trahan. I'll number the case.
Do you?
It'll be fine by next week.
He went to the hospital now.
Hmm?
He went to the hospital.
Yeah, it's Tuesday. Why not set till Monday?
You know where to find me.
Okay. Well,
If there's some issue that I find out of something that is a major issue where he would not be able to be here for trial, I'll check in before I number the cases.
when they call you.
I'll call them and let them know and talk to them before I number the cases, but I anticipate it'll still be numbered.
Thank you, Judge.
Good morning. Are you Joseph Roberts?
Yes, ma'am. Good one.
Good morning. This is 20-34226. Mr. Roberts, looks like you were on probation for the felony offense of driving while intoxicated and that you were placed on probation November 30th of 2020. That was a 7-year term in prison that was probated for 7 years. Some of the allegations, it looks like there is an additional driving while intoxicated charge from April 26th of 2026. Curfew issue, operating a vehicle without an ignition interlock device, and then some minor fees. Mr. Nix has filed a motion asking that I set bond in your cases. Currently, there is no bond. He's also handed me, it looks like there was a 30-day treatment at Level Up Treatment, Texas, that you went to April 26th through May 29th of this year. Mr. Roberts, best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. Mr. Nix?
Your Honor, we'd ask that the court set a reasonable bond. My client's willing to forfeit his right to drive. He would wear a screening device, comply with any curfew set by the court. As the court can see, he did not have any issues on the probation for several years until he picked up this new offense. It was not his vehicle. There were several other occupants in the vehicle, which would explain why he wasn't complying with the interlock device. He obviously knows that he made a pretty terrible mistake. And if the court will acknowledge, just 3 days after his arrest, he voluntarily did a month of inpatient rehabilitation. Also, I'd like the court to take knowledge of, and although I didn't put it in my motion, I think we've made the court aware with the district attorney. His daughter was brutally murdered about 10 days ago now. Somewhere around there, 2 weeks. About 2 weeks ago. Her daughter is his daughter's funeral is this Saturday. She was the victim of one of our homicides here in Beaumont out of a domestic violence situation with what appears to be a boyfriend or ex-boyfriend. He'd like to, be obviously on bail so that he can attend his daughter's funeral. He would adhere to any recommendations, anything that the court requires of him of his bond. He's also just been accepted into an IOP program where he will be doing counseling therapy for alcohol, substance abuse. As part of that program, they do random alcohol and drug tests. This is something that his insurance offered him after finding out about his daughter. So not exactly related to the DWI, but it's related to finding out that his daughter was murdered in the way she was murdered. He's taking advantage of that. Obviously, he doesn't want to have an episode where he falls off given what his family's going through. He is not the sole provider of his family, but he is the main provider of his family. They have 2 homes, one home that they live in, another home that they haven't been able to sell. So they have 2 mortgages to pay for and bills. Is that correct, Mr.
Yes,
And right now I'd ask if Mr. Roberts can give more details to the IOP than I might be able to. Can you explain to the judge?
What's the name of it or where is it? What's it through?
It's Trust Health.
Trust.
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 Yes, ma'am. We do 3-hour sessions, 3 days a week.
Is it on?
That's a group.
Is it on?
I do it virtual. I do virtual. Yes, ma'am. They do the random drug screening once a week, and we get a therapy session with a counselor also throughout the week.
How do you do your random drug screen?
They send an Uber and bring me to Quest on 9th Avenue. So
Have you already done one of those?
I have one set up for tomorrow.
Okay.
Yeah.
Where do you work?
There you go.
With Bechtel, Environmental Safety and Health Representative with Bechtel. For LNG.
So how would you get to and from work and things like that if you're not going to drive?
Yeah, my nephew also works out there, same shift, so I can ride with him.
Okay. Just for the record, I am reviewing the court's file, and part of that does include the probable cause affidavit for the new driving while intoxicated. I was looking to see, but I don't know that
It's not yet been received, Your Honor. Testing has not yet been completed.
I was trying to also see, do you have a copy of that previous pre-sentence report?
I had it on my computer earlier, Your Honor, to pull it back up.
Ours didn't, because it's an older case, it's not in here. Okay, please, ma'am. I guess an issue that I have that we're going to have to talk about. So Mr. Roberts signed a no driving agreement with probation March 19th. And then the allegations are that a month and a week after when this happened, he was driving. So he'd already told someone and signed an actual document saying he wasn't going to drive. So obviously the argument of I'm not going to drive gives me some concern because you already have been there, done that.
How many set of keys do you own?
Man.
No, to your
No,
car,
oh, I have one, my wife have one.
for the same car?
Yes, sir.
We'd be willing to turn over both sets of keys.
Wasn't driving his car on this date.
Fair enough, Judge.
So I'm not saying I'm not going to set it a bond, but these are the concerns that obviously, there was something going on that I'm not quite sure about, but obviously there was something going on for there to be a no motor vehicle drive form
Yes, ma'am.
signed a month before. So there were some concerns already.
I have previous PSI. from-
Sounds like it's coming as well over here. Thank you, Mr. Nichols.
Take it.
Mr. Nichols, what's your position?
Judge, I'd reviewed Ms. Molfino's email correspondence with the court and with Mr. Nix talking about her position on this case. We are not opposed to a reasonable bond being set. Obviously, we have concerns, same as the court, with the driving. I believe a scram will take care of any concerns about substance abuse, but there's just not an easy way to be completely certain about the driving. Given the circumstances, given his willingness to do what he's already done and what he's going through, that's why the state does agree for a reasonable bond in this case, Your Honor.
Okay, so Mr. Roberts, I want to make sure you understand, I'm going to set a bond, and if you make that bond, there will be some very specific conditions. Some of those conditions are conditions you already have on the probation. At this point, I understand that you're going through something very traumatic in your life, which tends to lead for people who have substance abuse or alcohol issues for those to get worse. If you don't take advantage of this opportunity while you're out on bond, I can assure you, you're not going to get any opportunity. You're going to be back in jail and you're going to be looking at going to prison for the 7 years that you've already agreed to on that underlying case and who knows what on the other. So this is make it or break it, going to prison type thing, even though it's just a bond. Do you understand?
Yes, ma'am.
So what I'm going to do is grant the motion to set a bond in cause number 20-34226. I'm going to set the bond at $25,000. I am going to order as a condition of that bond that you wear a scram device at all times. If there is a positive alcohol screening, I will know about it. There will be a warrant. There will be no bond, and we'll be looking at that 7 years. It's that simple. Also, as a condition of that bond, you are not to drive any vehicle ever. Period, under any circumstance. If you're with people and they're drinking, then you're not the one that drives. Y'all walk, y'all get an Uber, you do something else. You understand? Also, I am going to order as a condition of your bond that you, and really I want it to be a condition of probation as well, to modify your conditions of the probation you're currently on, to order that you can continue that program, the IOP, through Trust Health. I want proof of that, verification of that sent to your probation officer each week or whatever you can do. If it's online, you should be able to print something out to send to them to show that you're doing the 3-hour meetings, as well as any drug or alcohol screen that you get done. You need to get those results also to your probation officer. Okay.
Yes, ma'am.
So that'll be a condition of bond as well as your probation. Any other conditions that I didn't cover?
Those are the ones that I was concerned about. I think that'll cover it.
Okay. All right. So what we'll do, if you make that bond, you'll have another court date set. Stay in touch with Mr. Nick. He'll let you know when you need to be back here and in court. And again, whatever you need to take care of to keep yourself doing the right thing, going through what you're going through, you need to make sure and get that done, because being in prison won't help the rest of your family. Okay. All right.
Thank you, Judge.
Yes, sir. I'll shoot a message over.
Thank you. I appreciate it.
All right, Mr. Parker. On Gabriel Cruz. And Megan, I'll get you next. All right, sir, you Gabriel Cruz?
Yes, ma'am.
And we've got cause numbers 26 DCCR 0373. Mr. Cruz is charged with stalking. Cause number 26 DCCR 0374, charged with violating a protective order. And then cause number 26 DCCR 1060, charged with violating a protective order. And the state has filed a motion asking that I increase the defendant's bond. Hold on, I need to see what the bonds are in each case.
I believe they're
100,000.
100,000
In all three cases?
Well, individual, $100,000 in each individual.
300,000 total.
That's
Yes.
what I need to know.
Yeah.
All right. And has not made bond in any of those. Is that
He-
correct? Or he
He
has?
made bond in the first two, and then he picked up the last new case, and he's in jail on that case, on that. He has not bonded out on that charge.
And the last offense, it looks like has that same
The-
offense date. It was just indicted on, at least on my docket. Let me look at
Oh,
that.
no, it's
because-
a different offense state. It's my understanding.
Let me look. Oh, okay. Hold on a second. Offense date. It's not, okay. It's not. So the offense date in that last one is March 1st of 2026.
That's right.
So 2 weeks or so after the first alleged offense of violating a protective order. Mr. Coleman, you may proceed.
Yeah, I filed a written motion. I have no doubt the court's reviewed it. I'll just hit the highlights if I may, Judge. The criminal history, I just would ask that the court reevaluate the bonds in light of this defendant's criminal history that includes the conspiracy to possess or distribute cocaine out of the federal court, 2010, unlawful carrying a weapon, Jefferson County, 1994, possession of controlled substance, 1998, an adjudication for possession of marijuana, state jail amount of marijuana, 1998, and a arrest for an aggravated assault that was ultimately dismissed. I think it's still probative in this setting, that history. And in addition to the criminal history, Judge, I'd ask that the court consider the fact that this defendant allegedly committed this new offense of violation of protective order while out on bond for violation of protective order, and it involved the same victim, Judge. I think there are a lot of concerning issues here related to public safety and the safety of the victim in this case. I submit to the court that $100,000 bond on each of these cases is insufficient. I'm proposing a bond of $250,000 in this case.
Yeah.
I'd ask the court consider this.
I'm printing a couple of PCs as well. Give me just a second. I'm gonna get some stuff printed out so I can take a look at that. The PC in both of the in all of the cases. So
You do.
No,
y'all stop talking.
sorry.
Was there one more that printed or no? Okay, I see. So the, one of the stalking and protective orders the same.
Yeah,
He said.
That's right.
Mr. Parker?
Your Honor, I would like to point out that this is, he and his wife are going through a divorce and it's been nasty. Part of part of the communication or contact with her was because she wanted him to see the child and told him to come get the child. And that's why I was there. I think I can't just, and get me judged, I haven't talked to him after he bonded out, so I don't have a whole lot of information. And I just received a new case, so I'm not familiar with all the facts of the new case. So I'm limited to what I know. But my communication with him is that he's been contacted by her, and I'm sure she was admonished by Judge Freeze or whoever that to not contact him. But he did say that was one of the reasons she has contacted him to see his child, and then she tries to use that against him, and which is common. We see this a lot of times when there's a divorce going on, and they want to use anything they can. But we're asking that. I mean, he's on there's third-degree felonies, and $100,000 is a high bond. He had some help on the first two cases. I'm not sure if he's going to be able to have that help on these cases, but we're asking to leave the bond the same, $100,000 on with other restrictions. I think is appropriate for these types of cases. If he was out and was intended to hurt her, he could have hurt her. I think even the facts that Mr. Coleman has raised and some of the stuff is that if he was around her, he could have hurt her if he wanted to. But I think it aligns with what he is telling us, that he was, even though he shouldn't have gone over there to see his child, that's more than likely what happened. So we're asking to keep the bond the same, Judge, with other monitoring restrictions.
Killed myself, silly. What mom killed myself.
Right, so Mr. Cruz, if you have a protective order against you, I know what those say, and I know what the judges and the magistrates tell you about that. No one can give you permission to violate that protective order. And if you guys were just talking about a visitation of your child, I wouldn't have a probable cause that has an allegation that there was 96 text messages, 47 emails, 9 voicemails left stating that you don't care what the protective order says and that you're going to do what you want to do. In addition to pulling in the driveway, that's on February 23rd. 2 weeks later, same thing, numerous calls, and the officers locate you in your vehicle a block away from the house driving past. So it obviously, regardless of whether you have already done anything to hurt her, my job is to make sure that that doesn't happen. And I feel like you have completely disregarded the protective order that was placed on you and the rules that were placed on you down in another court. And so at this time, I'm going to grant the state's motion. I'm going to raise the bond and cause number 26 DCCR 1060, which is the last offense date of March 1st of 2026. I'm going to raise that bond to $250,000. Condition of that bond, if you make it, is that you wear a GPS monitoring device at all times and that you would be on house arrest as well. So you would not be allowed to leave your house. I am going to modify the conditions of your bond in the two other cases that you've already made bonds on. Additional bond conditions in those two cases, which is 26 DCCR 0373 and 0374, are that you have a GPS monitoring device on at all times and that you are on house arrest. You're not allowed to leave your house without my permission. All right, you can go back with the bailiff. We'll set your case for an announcement.
The bond amount stayed the same in that one?
Yes, I didn't
Okay.
change those bonds amount. I raised the last one
Okay.
and made those modifications.
Okay. I did. Hey, I actually need some. Hey, remember what I said, you're not going to get for the big from bond.
I was not that.
Tell your bonds.